Thank you very much, and yes, good morning to everybody. I hope you had a good night. I had one, and I look forward to be with you here. It's my first time in Latvia, definitely not my last one. I must say, a very friendly, wonderful country with friendly person. I'm surprised to see so many women judges here. I don't know how much the men feel about it, but I think this is certainly a very good development. I haven't much understood of the introduction except for Domēna and Kaffeepause. But just quickly, 2 to 3 sentences to my person. I have been educated as a German lawyer. I studied for a year in Geneva and also 1 year in the United States. I started to work as an attorney at law back in '97, which was just about the time when internet really became an issue. And just 1 or 2 years later, actually the first domain names showed up. And ever since, I concentrated on the field of trademark law, IP rights, with a special focus on new media. And that is what brought me to domain names. It's not only my first time in Latvia, but also my first time that I have the honor of being simultaneously translated. And I promised these two wonderful ladies not to talk too quickly, to allow them a little bit of time, and those who don't need translation might follow as well a bit better then. So yeah, I think that pretty much brings me to domain name law. What I should also mention is that since 2010 I'm working as a panelist for the World Intellectual Property Organization in Geneva, and that is, yes, kind of an aspect that is a little bit similar to your work. So I also have the duty to give decisions in a very specific way, which I will introduce to you later. When I was asked by WIPO to give this presentation, I was a bit struggling about the fact that I would speak to judges. Why that? Because probably you will not that often have a UDRP proceeding in front of you. So usually it's attorneys who represent their parties that file a complaint under the Uniform Domain Name Dispute Resolution Policy, and then it's a panelist like me who gives a decision. Still, I think the UDRP is a wonderful means to introduce you to basic principles of domain name law. And I also understand that there will be 2 more presentations today, one by my colleague Vestergaard from EU IPO. He will focus on EU aspects of domain name law, and then 2 colleagues here from the country code registry who will introduce you to Latvian domain name law. So what I will do is I will give you a very, very basic introduction in what is a domain name and why are there so many conflicts, especially for those of you who may not have yet that much contact with domain name law, which I think is a really, really interesting field of law. So, as I just said, what is a domain name at all? Well, first of all, it's a technical thing. It is the internet address of a website. It's unique, it only exists once, but it basically serves to resolve an IP address, which is lately the address under which any hardware that is equipped to the internet can be found. IP, by the way, does not mean intellectual property. It means Internet Protocol. So it resolves an IP address into a user-friendly form. Here you see the IP address of the WIPO, which translated into a domain name is wipo.int, and that is certainly much easier to recall than a series of numbers. It also serves to allocate email addresses, so whenever you register a domain name, you can also use that in order to have your own email address system, which I think everybody of you is familiar with. And then, and I think that brings us to the topic here today, first of all, it serves to transfer trademarks into the digital world. So I always consider domain names to be kind of the little brother of a trademark. So every serious trademark that exists today has its corresponding domain name. And that is why domain names are still, kind of so important to any major trademark owner. And that is why you will probably eventually also see domain names on your desk in your daily work. There are certain specifics about domain names, and they explain why domain names tend to cause quite a number of serious conflicts. As I already indicated, domain names are unique, so each domain name exists only once. If you combine this fact with the fact that domain names are registered basically on a first-come, first-served basis, you may easily understand that in certain situations there's a big run to get this one domain name that worldwide can only be there one time. And given the fact that, again, many domain names have a worldwide scope, especially the domain names under the so-called top-level domain name.com. So everything that stands behind on the right side of the dot is called the top-level domain name. It's the highest domain name. So usually most generic top-level domain names like .com, .info, .org, .biz, they have pretty much a worldwide scope. So once you have this unique domain name that may correspond to your trademark or not, if you are standing on the other side, then you have quite a monopoly into introducing this mark, this corresponding trademark into the digital world. And that is also important and explains why there are so many conflicts around domain names. They mostly function across markets and across classes of goods or services. So in the real world, you have many companies, many trademarks that peacefully coexist just because they refer to different goods or to different services, or they just exist in a certain part of the world. Not so for domain names. They usually can work across whatever is registered in a trademark register. They exist, and then it's up to the domain name owner basically to decide what to do with it. So this brings us to a first set of typical domain name conflicts. You may well understand that, especially for generic terms, it is likely that domain names will cause conflicts. So I chose this rather let's say, prominent example. First, only think of the term Apple. You can easily imagine that there will be tons of companies who could imagine to exist on the internet and to promote their trademarks under the domain name apple.com, maybe together with some kind of Apple SouthCalifornia.com. But still only thinking of people who really have to do with apples. There may be thousands who might be interested in a domain name apple.com. And if you then combine this truly Apple-associated companies with a company that has basically nothing to do with apples, but rather with applications, but is still today one of the most valuable trademarks in the world, then you can imagine that around the term Apple, you will have a workload of conflicts surrounding and keeping many courts all over the world busy. You also end into trouble with domain names if you think of identical personal or company names. And here I chose a very famous example under German law that goes back to the early days of the internet in around the year 2000. a person under the name Andreas Schell, that's his personal name. He's an entrepreneur in Germany. He registered the domain name shell.de. DE is the country code top-level domain name for Germany. And, well, just a couple of days later, the famous Shell company came and said, well, you might be called Shell, but I mean, frankly speaking, your name is Andreas Schell, isn't it? So we are Shell, and they actually sued him, and this court action was brought before the federal German civil court, who then decided in 2001 that the domain name actually was to be transferred to the Shell company. Basically, because they said if you have liked named persons, so persons with the same name, you have to do kind of a balance of interests. So who is the one who really depends on this specific domain name? And then the court held that even though Andreas Schell certainly may have an interest to exist on the internet under his personal name, he could easily use Andreas-Schell or any other variation of the Shell name, as opposed to the company Shell, who would rather have to have its trademark really as a domain name, as a corresponding domain name under the top-level domain name .de. And many, many conflicts of that kind we have seen ever since. A third category of typical domain name conflicts concerns trademark owners from different markets. As I already said, in the real world, I mean, our continent is still big enough to peacefully coexist under a same name if you come from different markets or maybe from different regions in the world. Not so on the internet. What I have shown you here is a very, very famous example of domain name sharing. We have two companies here, which is Mattel Inc. and Hasbro Inc. They actually own, in a way of a license agreement, the trademark Scrabble. I don't know if Latvians enjoy playing Scrabble. In Germany, it's quite a famous game. So when the internet came up and Scrabble was to be promoted on the internet, they needed to decide what to do about the domain name Scrabble.com. And they did something quite logically and reasonable. They said, well, let's share the world into two parts. So as we do in the real world, we exist in Northern America and in Canada as Hasbro, and the rest of the world pretty much is Mattel Inc. And we just take this shared domain name. We have an introductory page, and whoever wants to search for Hasbro goes on the link on the left-hand side, and the rest of the world goes to the right-hand side. This is a good solution. They didn't need to go to court for that, but you can imagine many companies won't be as reasonable as they were. I have another example here, which is, again, a German example. This is pretty much what I wanted to explain. You have two companies doing something completely different. The one is Volkswagen, who used to sell their most famous Beetle cars. Käfer. Käfer means beetle in German. They used to sell their Beetle cars, and Käfer is actually a quite famous German company for delicacies. So in the real world, I mean, there's really no reason why cars and delicacies should have conflicts with each other. Not so on the internet. And here actually they also did, for a couple of years, they decided to share the domain name käfer.de, and they could also peacefully coexist. Nowadays, actually, Volkswagen, in its attempt to globally promote its trademark. Käfer is not used anymore, what a pity. Now we talk about VW Beetle all over the world, but still. So, this now brings us to maybe the most, the field where you see the most types of conflicts, which are then to a high percentage resolved actually under the UDRP. That is the broad field of what we call domain name grabbing. If you recall, as I just said, that each domain name exists only once, and if you also recall that registering a domain name is much easier than registering a trademark. If you apply for a trademark, I don't know how expensive this is here in Latvia, but in Germany and in many countries in the world, you have to take quite a decent amount of money to register a trademark. So usually, only if you seriously want to use a certain term as a trademark, you would take the money and go for a registration. Not so for domain names. Domain names basically are cheap. They cost maybe $10, sometimes $50. You can buy a package where you get a whole lot of domain names for really cheap money. So you can also cause quite a lot of damage for really few money if you register domain names that conflict with existing trademarks. So what we see is tons of so-called typo squatted domain names. These are domain names that are composed of willingly, wrongfully spelled names, typo squatted domain names. So if you take the example of Yahoo, there's basically every kind of writing that you can theoretically imagine around the term Yahoo. So as you see here, I mean, the first one is maybe the most understandable typing error, so you just switch the first two letters, or you add an R like in Yahoo Mail, or you put Yahoo with two U instead of two O's, which you can imagine, I mean, somebody who's not that fluent in English, he might type in Yahoo with two U instead of Yahoo with two O. So we have lately seen roughly 50 WIPO cases just around Yahoo, but certainly that is not the winner in the list of typo squatted domain names. We have hundreds of cases around Lego, as you can see here, also very, a big variety of typo squatted variations, and I can assure you that the fantasy is really unlimited here, and sometimes you really think that it's almost insane what you see as typo squatted domain names. You may have to understand behind it that lately many domain names are registered automatically. So it's not somebody who sits down and thinks of funny typo squatted domain names, but you have systems that just create typo squatted domain names and automatically register them through automated systems. So that is pretty much why we have so many of these kind of cases. Another quite interesting example of how to abuse lately a domain name, of how to use it not in the sense as it is designed for, is what you find under passive holded domain names which do not really serve a serious goal, a serious need, but which are mostly used to run so-called standardized pay-per-click websites. So imagine, here I have chosen the example of wipo.info. That was a domain name that was registered really in the early days, and you don't find any information about WIPO here, which you would probably expect, but you get so-called links, third-party related links, which you can click on. And every time that you do so, you generate so-called pay-per-click commissions. That means the owner of this website, he gets really little, teeny tiny little amounts of money, like 0.03 cents per click, just for somebody who eventually ended on this website, but was actually looking for WIPO. And if you think that this happens 1,000 times a day, maybe 10,000 times a day, 1,000,000 times a year, this can make really a lot of money. So many typo-squatted domain names are abused in the sense that they are not used, but still they are generating significant amounts of money for those who own them. So this brings us now to the UDRP, and the reason why I have the honor to be here today. The UDRP dates back to 1999, the early days of the internet. It's the Uniform Domain Name Dispute Resolution Policy, which has been developed in a 2 to 3 year-long process and finally issued by ICANN, the Internet Corporation for Assigned Names and Numbers, which is kind of the master organization ruling over the domain name system. The UDRP is a quasi-administrative procedure. It's an arbitration proceeding, if you so wish, which is specifically designed for domain name disputes, so it has a really, really narrow scope. It is binding upon domain name owners by the moment that you sign a registrar-registrant agreement, so by the moment that you register a domain name, you are bound by the UDRP because every domain name registration agreement provides that the UDRP applies. So no domain names without application of the UDRP. It's a much faster and less expensive mechanism than traditional court actions, which is why it's a little bit of a competition to your job. But facing that there are so many conflicting domain names in the world, I can assure you, be happy for this kind of competition, because otherwise you would have all of this, sometimes really stupid things on your desk, and the workload would be enormous. It does not contemplate the use of any oral hearings or a discovery period. So if I talk about my job, being a panelist for WIPO, I'm sitting in my office in Frankfurt, and I get the complaint and every annex that goes with it digitally on my desk. I have access to a WIPO digital system, and whenever I get a new case assigned, first of all, I have to check whether I'm impartial, whether I'm not connected to any of the parties, and if that is so, I sign a statement of acceptance, I hand it down to WIPO, and then I get access to the case file. I can upload it. Usually I get between like 500 and 1,000 pages of pleadings and annexes. Most of them are useless, but still I get them, which is also a part of the digital world. I don't know if you face this here too. I think that there are many fascinating positive aspects about digitalization, but pleadings usually get longer and longer and not necessarily better. That is at least the experience that I have made. So I get access to these documents, and then it's up to me, all on my own, no parties in front of me, no discussions, no back and forth. It is up to me to give a decision. So you can understand it's a really quick and a really efficient procedure. The most important aspect probably about the UDRP is that the registrars are obligated to implement the decision. So the complainants will ask for either transfer of the domain name or for cancellation. By the way, cancellation is a very stupid means because the moment the disputed domain name is cancelled, it can be re-registered. And this happens quite often because there are automated systems on the internet which will grab up domain names that have been deleted or that have been cancelled. So I have been representing parties many years in UDRP proceedings as an attorney, and I would have never ever asked for a cancellation. Always ask for a transfer, and then you can still decide what to do with the domain name. But still, you have no difficulties with the going after the other party to get your decision really into a transfer of the domain name. So it's the registrar who has to transfer the domain name upon a positive decision. As I already said in the beginning, it's the UDRP is really limited to classic cases of cyber squatting, which we will focus on a little bit in more detail just in a minute. And that is also the reason why you will still have your specific type of domain name cases on your desk, whereas other type of domain name conflicts usually go to the UDRP. So I think, after all, it's still a very good coexistence between traditional court hearings in domain name cases and a lot of UDRP cases which are simply designed to handle different types of mostly typo-squatted, cyber-squatted domain name conflicts. As I said in the beginning, why is the UDRP of interest for your training? And as I already said in my introduction, I was really wondering what would be interesting for you to take with you home today. The UDRP operates across fact patterns, and mostly it operates across jurisdictions. So up until today, if I only talk about WIPO, maybe I should add there are 4 registries in the world that handle UDRP proceedings. It's WIPO in Geneva, it's the National Arbitration Forum in the United States. We have the Prague Chamber of Commerce Court, and we have a huge Asian UDRP provider. But only talking about WIPO, which still is the largest institution to handle UDRP proceedings, we have 37,000 UDRP-based cases in like 17 years, decided by roughly 500 WIPO panelists. And I think, and that is really interesting, we come from, at the moment, even more nations, but we have seen decisions covering 65 nationalities and 21 languages. And also the parties, they basically come from all over the world. Complainants you see from all over the world, respondents you see in particular regions of the world. So in my many years of UDRP complaint filings and decision makings now, I have been in contact with the Cayman Islands, very often with Kenya or with other places like the Bahamas, or even places that you have hardly ever heard of before domain name law became an issue. Because typo squatting domain grabbers, they often sit in fancy places in the world with a PO box office address, nothing else. So it's really difficult to go behind them. But still, UDRP is kind of really the essence of international domain name law. And that is why I think it's interesting to talk for another couple of minutes about what is UDRP, because you will get a feeling of what are the basic principles of international domain name law before you later on focus more on EU-related domain name law and then finally on your national Latvian domain name law. I would like to draw your attention without going into detail on the so-called WIPO Overview 3.0. You can look this up on the internet. It's quite a huge document. It has about 100 pages. It is kind of the, how would you say, it's kind of the Bible of UDRP panelists that work for WIPO. So all of these 37,000 UDRP decisions have been lately examined to now form kind of a jurisprudential overview of what is kind of a standard UDRP approach. So whenever I give a decision, I would certainly refer to the WIPO Overview 3.0 because, as we will later see, of course, UDRP panelists, just as you do under Latvian law, we also strive for kind of a steady jurisdiction. We don't want to have decisions to the left, to the right, up and down, but certainly it's important that complainants know what to expect when they file a complaint under the UDRP. So coming to the UDRP a little bit more in detail, what kind of disputes can be brought under the UDRP? You have basically three elements. We talk of the first, of the second, and the third element that really rules every proceeding and every decision under the UDRP. First, you have to have a domain name, a disputed domain name, which is either identical or confusingly similar to a trademark or a service mark in which the complainant who has brought the complaint has rights. What we mostly see are really registered trademarks, as you know them from conventional trademark law. What is also accepted under the UDRP are common law trademarks, certainly, especially when you have conflicts with English or United States or any other common law country parties. You will quite often see complainants that call upon common law trademarks. But basically what you usually get is just a trademark register excerpt from any national or international trademark register. And the complainant says, look, I have a trademark and here's a domain name and I claim that it's either identical or confusingly similar to my trademark. The next step is that the respondent, the domain name grabber in most cases, may not have rights or legitimate interests with respect to the disputed domain name itself. And thirdly, the disputed domain name must have been registered and must be used by the respondent in bad faith. As I already said, the first element, which is that you have to have a trademark or a service mark, is mostly a standing requirement. So panelists will not be too strict about this element. So this is kind of the entrance into the whole proceeding. So if you think of the question whether a trademark is, let's say, confusingly similar to a disputed domain name, we would be rather generous. We would, especially when it comes maybe to word device marks, you would certainly say as long as the disputed domain name can be recognized within the trademark, you are fine. So we have hardly ever seen serious UDRP complaints brought by serious trademark owners that would fail under the first element. So confusing similarity should not be mixed up with what we know under traditional trademark law being a likelihood of confusion. I don't know how it works under Latvian law, under German law, and under many international trademark law systems. Likelihood of confusion can be a very, very complex element in a trademark dispute, where you really have to weigh whether or not you have maybe in a word device mark a device element that is decisive for the overall impression of the trademark or not. Here you really cut it down to a very, very basic introductory question. Can you somehow say that the disputed domain name and the trademark have something in common? So confusingly similar is a lower standard than is likelihood of confusion. Coming to the second element, as I said, the respondent must have no rights or legitimate interest with respect to the disputed domain name. And I mean, this is a quite vast term. So the UDRP actually provides for a number of standard settings where a respondent can show that he has legitimate rights to a disputed domain name. So if you think of a bona fide offering of goods or services under a disputed domain name, so if a respondent can show, well, I mean, before I had any idea of your trademark, I was using the disputed domain name for a bona fide, a good faith a good faith offering of goods or services, then of course you can claim to be entitled to the disputed domain name, and nobody would say that this domain name needs to be transferred upon the complainant. Also, if a respondent is commonly known under the disputed domain name, which the trademark owner may have not been aware of, then again the respondent can say, look, I'm entitled to keep the disputed domain name. Or, and this is also a very, very often called upon element under the UDRP, if a respondent can show that he is using the domain name legitimately for non-commercial or fair purposes, without any intent for commercial gain. And we have seen many very interesting UDRP cases relating to United States parties, where the respondent was claiming to make use of its right of freedom of speech under a disputed domain name. So imagine that you have, let's say, a big company, a pharmaceutical company, that seems to distribute pharmaceutical products that might cause negative effects. And somebody is blaming them for doing so. And this person, let's say the company is called ABC, and the person registers a domain name that is called abcnegativeeffects.com. Then, of course, the company ABC is really, well, unhappy with that and would like to have this domain name put to the side. And probably ABC and ABC negative effects is confusingly similar. Still, the respondent can show, look, I have a legitimate interest to tell to everybody in the world that your products cause negative effects. And especially in the United States, the principle of freedom of speech is upheld on a very, very high level. And we have seen many UDRP panelists from the United States who would say in these cases, no transfer of the disputed domain name. This is legitimate, non-commercial fair use without intent for commercial gain. Something that is connected to the second element, which I would want to quickly address too, is the fact that it's quite often almost impossible for the complainant to demonstrate that the respondent has no rights to a disputed domain name. Because, I mean, this is proving a negative. And most often the facts that really tell you whether or not a respondent has a right lies totally under the control of the respondent. So how should a complainant be able to prove this negative fact? The solution is quite simple. You may know this, of course, under your national laws too. UDRP panelists have held that where a complainant makes out a prima facie case, that the respondent lacks right or legitimate interests, then the burden of producing the counterproof shifts to the respondent. So as long as I am, being the complainant, show to the panel a reasonable case setting, a reasonable set of facts that would, let's say, give the impression that it's more likely than unlikely that the respondent has no rights to the disputed domain name, then it's up to the respondent to file a response that demonstrates the contrary. And under this aspect, it is certainly important for you to know that about 80% of UDRP cases are so-called default cases. So no respondent ever files anything. So, like in courts, if the defendant doesn't show up, then of course you may call him in, you may issue a court order, but I assume that in most civil law cases you also have the concept of default situations. If the defendant doesn't show up, well, bad luck, and then the claimant prevails. Same under the UDRP, if the complainant brings a reasonable case, and if the panelist says, well, I am pretty fine off with with the fact situation that has been brought before me, and if the respondent does not file any response, then the decision will be granted and the domain name will be transferred. And this happens in most cases. I would say 80 to 85% of the cases are default cases, and that also shows to you why UDRP and court proceedings can quite easily coexist, just because UDRP really faces for a different type of settings. Every conflict that is a reasonable, a serious conflict where you can really argue forth and back, where you have arguments for both sides, should never be brought before the UDRP, but this belongs before a national court. So this brings us finally to the third element, which is maybe the element where we say that is where the beef is in. So that is where the dispute really becomes interesting, if it's an interesting dispute at all. So it's again the complainant who must show that the respondent has registered and is using the disputed domain name in bad faith. And in the early days of the UDRP, there was a little bit of an uncertainty how to read the UDRP. Is it really and? So what if somebody registers a domain name in bad faith, but then eventually decides to use it itself? Or the other way around, you registered a domain name in good faith, but then decided to use it in bad faith? The very first UDRP decisions, they picked up this question very quickly and decided, no, it's conjunctive. So you have to register it in bad faith and you have to use it in bad faith. So again, this shows UDRP is really designed for very narrow cases, and anything to the side belongs to your desk. Bad faith, what is bad faith? It's a principle that I think, again, exists in most national law systems. It's pretty much where the respondent takes unfair advantage of or otherwise abuses the complainant's mark. And if you think of typo-squatted domain names, the abuse is often already introduced and induced by the way in which the disputed domain name has been composed. I mean, if you sit down and think of a funny typo-squatted version of a famous trademark, I think the bad faith element is pretty much already shown. Again, in order to give parties and panelists kind of a guideline, the UDRP provides for a set of typical circumstances which would be proof of bad faith use. So if you, for instance, acquire the domain name primarily for the purpose of selling it, so if you really create a domain name where you think this will be really hurting upon a trademark owner, then bad faith is pretty well shown. Quite often you see cases where a disputed domain name is composed to prevent that a trademark owner can use its own trademark. So especially if you think of somebody who is about to launch a new trademark, and a staff member of the company who has knowledge about this launch, he goes and registers 10 domain names just around this new trademark, then I think it's pretty much clear that this was bad faith. We see cases that are even more focusing on causing damage. So sometimes you even register a domain name in order to disrupt the business of a competitor. But most cases you will find under the fourth example, and that is if you register a domain name with the intention to attract for commercial gain internet users to your own website. And this is usually what happens with typo-squatted domain names. If you think back of the Yahoo case, you switch the first two letters, you get internet traffic on your own website, you generate pay-per-click commissions, you get money from this typo-squatted version. This is usually something that falls under this fourth element to demonstrate bad faith on the part of the respondent. This pretty much gets me to the last set of information which I wanted to drop with you, which I think is particularly interesting for you, namely some procedural issues under the UDRP. So first, what deference is owed to past UDRP decisions? So as I already said, on the one hand, UDRP decisions are not binding. UDRP does not mean that we are in like a common law system where you have, let's say, the principle of stare decisis, which means that the decision must stand. This is a very important principle under common law systems. So UDRP decisions are not binding. Still, UDRP panelists are really aiming to give predictable decisions. So if a complainant decides to go for a UDRP proceeding instead of a court proceeding, it's really helpful to him to have an idea, can this be a successful proceeding or not? So that is why we have this WIPO Overview 3.0, which is kind of really a summary of the most important decisions by UDRP panelists. And when giving a decision, we would often refer to these principles. And whenever you get in touch with a domain name case, I can really recommend to you have a look into it, because you get really kind of a, kind of the extracts of international domain law principles, and you get at least a good feeling where a case might go. What is the applicable standard of proof? As I also indicated, it's kind of a balancing of what I have in front of me. I have lately had a couple of complaints, and I must say they were really bad. So the complainant had done an awful job. And sometimes you have really big companies and really famous trademarks. And still, if the attorney or the representative of the complainant makes a bad job, bad luck. So, you really have to bring something in front of the panel as a party would need to bring in front of you, and it must be convincing. It must be more likely than unlikely that the disputed domain name should go to the complainant. What you probably issue here and then, and we do the same, we are allowed to issue panel orders. So if a complaint is really bad, and I still think that the case is still a clear case, I sometimes issue a court order and help the complainant to do a better job and say, look, the panel is not totally convinced that, so you get another 5 days to hand in something, but this is rather the exception to the rule. So UDRP is one shot. You put in front of the panel what you have, and either it's enough or not. The relationship between UDRP and court proceedings, again, it's not competition. It's really, I think, two different systems. And the UDRP does not prevent any party to file a court action. So you can even file a court action while a UDRP proceeding is already underway, and then it's up to the panelists to decide what to do with it. We have the possibility to suspend a UDRP proceeding, which we are rarely doing only because we think as these two systems really coexist, we should rather go for a quick decision, and then it's up to the national courts to say, well, this is kind of an indication where the case should go, or I take it de novo. I really take it from the scratch. I do not feel bound by the decision at all. So it's kind of a different approach. UDRP is for specific cases. And if you ever get into a situation where you have a domain name case and a parallel court proceeding, when you have a domain name court proceeding and we have a parallel UDRP proceeding, I'm pretty sure that there will be a friendly coexistence and that the UDRP panels will somehow look how to match this with the court proceedings. By the way, there's no appeal system under the UDRP, but if the respondent is not happy with the outcome, he has 10 days after the decision has been given to go to court and to bring a regular proceeding, and then the decision will not be implemented. So the decision will be set aside. This rarely ever happens, but we have seen a couple of cases. And then the final aspect here, to what extent is national law relevant under the UDRP? Well, again, UDRP functions across borders, across nations, across countries, mostly because we see parties from different nations. So basically, national law is not relevant, except that, and this happens sometimes, if the parties come from the same national background, from the same legal background, then it might well be that we will, as panelists, infer some principles of our national law. So the WIPO, for instance, would ask me to take over a case where 2 German parties are involved, if they think that this could be a case where German law comes in. If that is not the case, it's not for national law, but it's rather for international law principles. So the time's over. I hope that you could catch something for you. I would really want to draw your attention to the WIPO page, where you find a lot of more information which we didn't really want to print out here. But again, if ever you strive a domain name case, you will find, I think, some ideas, some principles, some guidelines which might help you in your daily work. And I thank you very much for your attention.